Hey, faithful politics listeners and viewers. If you're watching on our YouTube channel, I am Will Wright, your political host, and Josh Bertram, our faithful host, can't be here today. Unfortunately, he is busily reading through the Pandora Papers to ensure he's not indicated or implicated in any of the stuff that they have found there. So, in his place, we have returning champion Professor Eric Berger. He teaches constitutional law at the Nebraska College of Law. And a lot of his work explores judicial decision making in constitutional cases. And I think he's the perfect person to talk to us today about vaccine mandates. So welcome back, Eric. Thanks for being here.
Well, thanks very much for inviting me again.
Yeah. And I forgot, I just called you Eric, so I apologize if I should be calling you.
That's perfect. Okay. Thank you.
Good. So, so today we want to talk about, a lot of the conversation that you're hearing today in the news about vaccine mandates. Some states have actually already kind of started doing this, to a greater or lesser success. Some states seem to be more successful, some others, but I'd like to kind of maybe just start first with, 30,000 foot level view of can the government mandate vaccinations?
Right. So that's a great question, and obviously a really important one. And as is often the case in law, especially in constitutional law, the answer is it depends, and it really hinges on a variety of variables, such as who is putting the vaccine mandate into effect, what exactly does the mandate do and say, who exactly does it cover, and how is the government putting it into effect? Sort of what procedures is the government using? And depending on the nature of the mandate, one could imagine different kinds of legal challenges to vaccine mandates. And the outcomes of the cases, some of them I think are probably not that clear, but the analysis the courts would engage in will really depend on the particulars. So, if it's okay, I'll spend a couple of minutes just sort of going through some of the possibilities. So I think vaccine mandates put in place by state and local governments typically are going to be on a stronger constitutional footing, with some caveats, than sort of a broad federal mandate. State government enjoys a sort of broad police power, and by police power, that doesn't mean just the police force. It means a broad authority to take measures to protect the health, welfare, and safety of its citizens. So, I think from that standpoint, a state mandate is, presumptively constitutional, although again, it depends exactly on how it's done. So, for instance, I think where a state would be on particularly strong grounds is if it targets people within a particular state community that don't have to be a member of that community. In other words, that can opt out. So, for instance, if a state university put in place a mandate that all students and employees at the university get vaccinated, or if a state required all state employees to get vaccinated, I think those kinds of mandates would be on strong constitutional footing, at least under the federal constitution. I'll talk about state challenges in a moment, but I think challenges to those kinds of laws will probably be unsuccessful. Probably in part because there's no requirement that you attend a particular state university or that you work for the state. So if you really don't want to get the vaccine, you have the option of opting out. To the extent some people will challenge a vaccine mandate, you say a state vaccine mandate, saying, well, this violates my right to bodily integrity, the right to make my own medical decisions and decisions about my own body. As you've mentioned to me before, the Supreme Court rejected that kind of reasoning in 1905 in a case called Jacobson v. Massachusets. Obviously, Supreme Court constitutional doctrine and the court itself and the world has changed a lot since 1905. But I think that holding still probably can do some work in the state context, in that a vaccine mandate, particularly if something like everyone at a state university has to get a mandate, is on pretty sound constitutional footing. A few caveats. One point is that a broader law saying everybody in the state has to get vaccinated, I think that's probably on somewhat shakier ground. The Jacobson case from 1905 would suggest that even that kind of broader law would also be upheld. I think courts today might be a bit more skeptical of that sort of a broader rule. And again, I think the difference between saying, not everyone that's in the state has to go to a state university. So if you want to be part of our community, you have to be vaccinated. And if you don't want to, you can withdraw and go to another school. That option doesn't exist as easily if you say every person in the state needs to be vaccinated. So a sort of broad across the board mandate for an entire state population would be more legally vulnerable, although Jacobson would still be a helpful case for for states that were trying to do it. I don't think we've seen states try to do something that broad, and I'm not
Mm-mm.
sure in our environment they would try. But Jacobson, would be a helpful precedent. It's just it's a question of whether courts would follow it as sort of broadly as that was written. Um, you know,
Can I ask you a question first,
yeah,
about that? So, like, based on what I know about Jacobson, and I'm not going to pretend that I'm some sort of constitutional scholar like yourself, but I just play one on a podcast. So with Jacobson, based on my understanding, there was like a $5 penalty for I believe it was Jacobson to opt out of getting the smallpox shot, and which I think would equate. I think I saw like an estimate like $140 or something like in today's money or what have you. But because there was sort of this opt out provision, this monetary opt out provision, um, like if it were to be used and or cited as I don't know, evidence that an institution can mandate a vaccination requirement, would the penalty have to be equally I don't know, like bearable or unburdensome to the person that wants to opt out?
you know, that's a good question, and I don't know that that's a question that has been definitively resolved. But I do think one thing a court would consider is how coercive is the penalty. So,
Mm-hmm.
um, I can't imagine a state doing this, but if a state were, for instance, to say, you need to get the COVID vaccine, or the penalty is 10 years in prison, I think a lot of courts would balk at that and say that's just way too harsh a penalty. And even though the state has broad authority to protect health, that's overstepping its grounds. But a reasonably small monetary penalty, like the one in Jacobson, I think would be more likely to be upheld. But again, it is a different world, and the Supreme Court today is pretty conservative, or very conservative, and I think would be more willing to find governmental overreach um, in something like a vaccine mandate. Although again, I think if it's coming from the state government, the the Jacobson case would still be seen as important authority. And in that case, again, the court said, essentially the state is permitted to require vaccinations. And while the state power is not unlimited, um, the it is within that power to require vaccinations, at least for someone for whom the vaccine would not cause illness. So you would have to carve out an exception for someone who could document that the vaccine would cause illness. But I do tend to agree with you that the penalty for not complying could not be too onerous, or that would be that would likely be seen as an overstep. I also, this was something I was going to talk about a little later on, But I also think that a religious exemption, the states contemplating this should think strongly about putting in place a religious exemption because the Supreme Court today and the federal courts are, very protective of religious liberty, and they would be more likely to, Jacobson was not a religious liberty case, even though the person objecting to the mandate in that case was a minister, but he wasn't objecting on religious liberty grounds. He was objecting on sort of basic liberty, bodily autonomy grounds. What we talk about is substantive due process, the liberty component of the due process clause of the 14th Amendment. That's a different argument than a religious liberty argument, than the argument that it violates my free exercise rights. I think a free exercise challenge to any kind of vaccine mandate, given the nature of the federal judiciary today, is more likely to succeed. And I think for that reason, you'd see governments that are putting in place vaccine mandates would be more likely to include a religious exemption.
Yeah, because the religious exemption, it's Title VII, I believe, like in the ADA or what have you. And I'm curious on like how would that look? I mean, I haven't read a whole lot of cases or read a lot of articles about successful religious exemptions, but I know plenty of people that have already told me that they're going to file religious exemptions if there is a requirement, even with like the proposed emergency temporary standard by Osha, 100 employees or more, they're going to be required to vaccinate their folks. And I know, at least just knowing what I know about OSHA's, there is sort of this accommodation process. And as long as it's not going to put an undue hardship on the employer, they have to do it. So, I'm curious if you know anything about kind of like the religious exemption world, and what kind of things do you expect, for courts to kind of be considering, as these cases kind of get brought forward?
Right. So that's a great question. I'm going to put the OSHA question to the side for a moment because, as I said at the outset, judging the constitutionality of this really depends on who is putting the mandate in effect. And when it's the federal government as opposed to a state government, there are all kinds of different constitutional and legal kinds of challenges in play, and I do want to talk about those. But regardless of whether it's a federal or state or city putting a religious or putting a vaccine mandate in place, there's the possibility, as you say, of a religious challenge. And unlike something saying, well, the federal government doesn't have the power to do this, and I'll talk about that in a few minutes, this would be an argument that the vaccine mandate put in place by anyone offends my religious liberty. It's a similar kind of individual rights-based argument to the sort of bodily integrity argument that I just talked about that, I think is less likely to succeed because of Jacobson. I think a religious liberty argument probably is more likely to succeed, again, because this Supreme Court is extremely protective of religious liberty. And I think you could see that kind of challenge coming, there might be sort of statutory specific challenges, but in terms of general religious challenges, if a state put it into place, you could see someone challenging it just on First Amendment free exercise grounds, saying this violates my First Amendment rights to exercise my religion freely. If it's the federal government, they could invoke the Religious Freedom and Restoration Act, which Congress passed in the mid 1990s to heighten the religious protections. Congress's original intention was to apply to both state and federal actions, but the Supreme Court, in a case called City of Bernie, effectively limited it to just the federal government. But so whether the challenge is coming from the First Amendment's free exercise clause, as it would if it were for a state government mandate, or RFRA, the Religious Freedom and Restoration Act, which it would for the federal government is going to have a heightened burden to keep the vaccine mandate in place. And essentially the courts would be applying what constitutional lawyers refer to as strict scrutiny. So the government would need to show it has a compelling governmental interest and that interest is narrowly tailored or even necessary to achieve that interest. I think the compelling interest standard is pretty clearly met. The government does have a really compelling interest in protecting the health of the community. So I think the fight would be over whether it is necessary to achieve that. I think there's a reasonable scientific argument that it is necessary to achieve it. There have been a lot of scientific experts who have said the best way to get out of this COVID pandemic is to get everyone vaccinated or to get as many people vaccinated as possible. And, we've seen with all the deaths during the Delta surge that's the vast majority of those deaths have been from the Delta variant for unvaccinated people. So people have been referring to it as a pandemic of the unvaccinated. So I think there is a plausible and, frankly, in my view, pretty strong argument that a vaccine mandate should be able to survive those religious freedom challenges. However, I don't know that the US Supreme Court would see it that way. As I said, this Supreme Court is very protective of religious liberty, and my instinct is you would be able to get 5 votes that would. Again, it depends on who's doing the mandate and how they're doing it. But my guess is that at least for some vaccine mandates, they would be they would be likely to uphold a religious liberty challenge and say, well, you need to give an exemption on religious liberty grounds. Now, again, the government can avoid that by including a religious liberty exemption in their mandates in the first place. In other words, they could say everyone needs to get vaccinated except if you have, a documented health reason to show why the vaccine is dangerous for you, or if you have a religious exemption. Obviously the danger of that is if a lot of people, I don't think a lot of people could take the first one, but if a lot of people took the second one, that can undercut the whole purpose of the vaccine mandate in the first place. And just one other point about religious exemptions and free exercise clause generally. There's a huge fight going on in constitutional circles about what the standard should be for challenging a law that burdens the free exercise of religion. I think most people agree that if a law targets religion, it's very constitutionally suspect. In other words, we shouldn't allow government to do things that go after religion. But the difficult question is, what if the government puts in place a rule that applies to everyone, like a vaccine mandate, but doesn't allow exemptions for people who say that those practices, or rather that requirement offends their religious practice? In a case in 1990 called Employment Division v. Smith, the US Supreme Court applied what's called rational basis review to that kind of a challenge. And it said, we're just going to, as long as the government is acting rationally, we're going to uphold this and let the government do what it wants to do. In other words, it basically said, we're not going to give religion a whole lot of extra special protection. And that opinion actually was written by Justice Antonin Scalia, a very prominent conservative on the Supreme Court. I think what Scalia was concerned about, in part at least, was the problem of religious imposters. I think he was concerned that if you say, well, you can get an exemption from a generally applicable rule, as long as as long as you claim that it offends your religion, people are going to be coming out of the woodwork and saying, this violates my religion, this violates my religion. And that leads to kind of legal chaos because everyone is going to be able to claim exemptions from laws they don't want to follow. So I think that kind of concern was was at least a substantial part of what motivated Scalia and some other justices and Smith to say, So long as the government is acting rationally and so long as it is not deliberately targeting religion, we're not going to give religion special treatment. The Supreme Court today sees these matters very differently, and I think is much more solicitous and protective of religious liberty. Um, and if in fact we end up with a bunch of vaccine mandates that allow for religious exemptions, I think it'll be really interesting to see, are these exemptions claimed by lots and lots of people or just a small set of people. Framed somewhat differently, there's some religions that that might have a long standing, and I'm hardly a religion expert, but you could imagine a subset of religions that object to medicine or vaccines generally. So the question would be, would a lot of other religious people who are parts of denominations that historically haven't still claim those exemptions? I don't know if how that plays out is going to affect this Supreme Court's thinking on these issues now, but I think it could affect how the judiciary views such questions a generation or two from now. In other words, if you get tens of millions of Americans who suddenly say, this violates my religion, when they hadn't been talking about vaccines a year, 2 years ago as violating their religions, I think that might make the courts 50 years from now less protective of religious liberty precisely because of that religious imposter problem. But again, it's all speculation. It's hard to know.
Now, Eric, so in a religious exemption case, like who bears the burden of proof? Like, I mean, like I officiated a wedding for a friend of mine in Washington State, and kind of just as a joke, I got an ordination through the Church of the Flying Spaghetti Monster. It's an actual nonprofit. They've sort of like they call their congregants Pastafarians, and like for all intents and
I'm sorry, it's funny you mention that because I think I cite that example when I talk to my students about it, about the exact kind of thing that Justice Scalia was worried about. He doesn't want these Pastafarians getting exemptions for laws that should apply to everyone else.
Mm-hmm. Yeah, so I mean, like in that situation, I mean, like if I mean, I'm a believer. I have a pretty deep rooted faith, and I have not saw any need to file any sort of religious exemption in my workplace to not get the vaccine. Now, other people sort of in my same faith circles might apply an exemption. So if you're like the employer, or if you're like, I don't know, an agency, and you're like, okay, I know where that person goes to church and I know where that person goes to church. They go to the same church, and one is filing a religious exemption and the other's not. Who has the onus or burden of proof like in those situations?
Right. So, historically the courts have, basically said as long as it is a personally believed religious belief, as long as it is a genuine religious objection, the court is not going to scrutinize whether it is part of religious doctrine or something like that. So in other words, basically, as long as an individual, testifies that it violates their religious beliefs, they're going to get the benefit of the doubt and be entitled to the exemption that they're claiming. So, and I think that's for good reason, which is we don't want the Supreme Court scrutinizing a bunch of religious doctrines and asking, well, is it really a core tenet of Methodism or Buddhism or Hinduism or Pastafarianism to ask for to say that vaccines violate our religious beliefs? So I think, the court sensibly has stayed out of trying to second guess whether a person's asserted religious objection is genuine or not. They take it sort of at the person's word that it's genuine or not. Again, I think because of that, that's part of what was motivating Justice Scalia and some other justices in 1990 to be concerned about religious imposters. That concern doesn't seem very prevalent at the Supreme Court today. I think the Supreme Court today is much more concerned with government and society generally not being respectful enough of religion and not going and not allow and interfering with religion. So so I think they think about these questions quite differently. Again, the point I was making about is if you see so many people, let's say in the next 6 months or a year, claiming religious objections to a vaccine mandate, and those people are members of religions that had not seemed to be concerned about vaccine mandates 3 years ago, that might lead courts and scholars to sort of second guess the way they think about these things. But I don't think that would happen in the short term. I think that would be a multi-decade process because, again, this Supreme Court is very protective of religion, and the lower federal courts are going to have to follow their lead on it.
Yeah, I just want to ask you one more question about sort of religious exemptions. Would a court take into consideration other vaccines that individual may have had, such as, like if you're a nurse and you have to get the flu or hepatitis or whatever, or would they consider each vaccine as sort of separate, like a separate or new case to examine?
Right. That's a brilliant question, and I'm afraid I don't have a brilliant answer to it. I think, I could imagine some lower courts looking at a person skeptically if they have willingly and happily taken other vaccines throughout their lifetime and then claimed a religious objection to getting the COVID vaccine, because that seems more like a political objection than a religious objection. And I think, if that in fact happens, it's, in a way, I think it's bad for religion and bad for constitutional law, because I think it's going to make people more skeptical of people claiming religious objections. Again, because the Supreme Court historically has really just asked, is this a genuine, heartfelt religious belief, and not scrutinized it further than that, I think at the end of the day, people would be able to say the COVID vaccine in particular violates my religious beliefs. But again, for exactly the reason you suggest, I think that could raise some eyebrows that might have doctrinal ramifications, again, more likely down the road than in the short term.
I got it. So you were talking about, the applicability of mandates varies depending on kind of like the who is requiring the mandate, and I think that you had finished talking about kind of state or institution mandates, but what about like a federal?
Can I say one more thing quickly about the states, if that's okay, before?
Yeah.
So I've been talking about federal constitutional challenges to state mandates. It's possible that there could be constitutional challenges under state constitutions. Each state has its own constitution, and in particular, each state allocates power somewhat differently. So, one thing I tell my constitutional law students is that constitutional law is really a class about who decides, who in our system has the authority to decide a particular question. And in a particular state, it could be, for instance, that, say, the governor puts in place a mandate. One could imagine a successful challenge saying, no, that's not the governor's role, that's the legislature's role. Or a city putting in place a mandate and there being a challenge as to whether the city has the authority to do that or whether it needs to come from the state level. So in other words, those kinds of challenges could come up in the context of state constitutional law about who within a particular state has the authority to put in place a vaccine mandate. And obviously those kinds of questions would then turn on the particulars of that state's constitutional law, which is something I'm not an expert about. But I just flagged that to make clear that is that there's state law issues as well, in addition to the federal law issues I've sketched out.
Okay. And so federal mandates, specifically, I don't know, it's my understanding that, if the Biden administration says, okay, all federal workforce, all military, all DOD, what have you, have to get vaccinated, then like thus has to happen because it's within sort of his executive level power, right? Like, is it pretty like, what's the word I'm looking for? Like, is it true that basically he could just, snap his fingers and make it so?
I think the federal government does have broad authority to put in place requirements for federal employees. Um, I think a tougher question is whether the federal government can put in place using OSHA vaccine mandates for workers across the country, including private employees. And once again, I think the answer as to whether that's legal is it depends, and there are lots of different kinds of questions um, that would come up. So as you know, as you and I have talked about, President Biden announced that OSHA would be designing rules to require federal workers to get vaccinated. And critics cried, "Well, this is unconstitutional." There's certainly legal challenges that are plausible that could be mounted against that action. But to just say it's unconstitutional is, I think, a little bit overly simplistic. So once again, if it's okay, I'll just sort of break it. I'll break it down into
Mhm.
some of the different kinds of challenges we could see. Um, one question is, well, does OSHA have the authority to do this at all? And that would depend on the authority Congress has delegated to OSHA. In other words, OSHA is an administrative agency dealing with occupational safety and health. Congress has delegated to OSHA authority dealing with those kinds of things. The question is, has Congress delegated to OSHA broad authority to set workplace health standards? I think and I'm not an expert in OSHA, although I've looked into this a little bit. I think the answer is probably yes, as a general matter. OSHA does have broad authority to set workplace safety and health standards. Vaccine mandates are clearly a matter of health. So there's a good argument that Congress has delegated to OSHA quite a bit of authority here, and that would certainly help bolster the legality of President Biden's plan. But let me point out that that doesn't mean that that authority is unlimited. So, for example, OSHA, I would think, should have more authority to impose a vaccine mandate for federal workers working in person than a federal worker working remotely at home. If a federal worker is working in person, there's a good argument that that person needs to be vaccinated to protect him or herself and coworkers against COVID-19 and the Delta variant. But if a person is just working out of a home office and is not interacting with other coworkers, the need to vaccinate that person to protect workplace safety isn't really there, or it's certainly not as strong. Now, there's still other good reasons for that person to get vaccinated, but they might fall outside the ambit of OSHA's reach. Yeah,
Mhm.
so as to OSHA's authority, my instinct is that OSHA has quite a bit of authority, but it's not unlimited. Um,
Yeah.
you know, and,
Can I can I
yeah,
can I I guess just challenge that just a little bit, because like for the listeners or viewers that don't know, my day job, I work in sort of the field of safety, and um
I should just throw these questions back at you. You know more about this than I
yeah.
do.
so like and it I could probably make an argument, like, I've always thought that if my safety career didn't pan out, I'd be like one of those like accident attorneys, those ambulance chaser types. But like, like in the home, if you're teleworking, And you have an injury in your house. So say like you got a work printer and the printer jams and you try to unjam it and you cut your finger, then you have to like report that to OSHA. It's what they consider like a recordable. It gets documented on this thing called an OSHA 300 log and so on and so forth. I could argue a vaccine mandate would be required even if you're working at home, if you live or cohabitate with somebody, because the idea of getting vaccinated is to protect the worker, and without kind of knowing the health or medical status of the people that may live with you, it's protecting you in your work environment. And if your work environment is in the house, then your kids, your spouse or whatever, like you're protected. So I don't know. I mean, like I think where they'll run into trouble is if the federal guidance that's put out by the Safer Workforce Task Force, or Safer Workplace Task Force, I think it's called. If they say vaccinated, or you have to be vaccinated if you work from home, which I think that's what it currently says, and then OSHA gives you an out and says that you don't have to be vaccinated if you work at your house, I think that's going to create a ton of confusion, kind of just within sort of the general population. But yeah.
So I mean, I think it's a great point, and I think the argument you're making is certainly a plausible legal argument. And again, there are very good public health reasons why even the stay-at-home worker should get vaccinated. But I guess the point I was making is that OSHA's authority to put in place that kind of mandate for someone who is just working at home. Imagine the single person who lives alone who's just working at home is going to be a closer question than their authority to put in place a vaccine mandate, to imagine a large workplace with 1,000 workers in close quarters, interacting in person every day. So the point I was making was not that OSHA clearly doesn't have the authority, but just that that kind of a challenge to OSHA's authority from the lone worker working remotely at home is a more plausible challenge to OSHA's authority to put in place the vaccine mandate than it would be for in-person workers. But you're right, that one argument to just say that it should be the same rule for everyone is that it is confusing and chaotic if there are different rules for different people. And I think a couple of decades ago, that argument would have clearly been a winner, to the extent that the Supreme Court and the federal judiciary generally is more skeptical of federal power than they were, say, a generation ago. I think it could be that those sorts of different situations will produce different results. Again, I don't know, but I think those are the kinds of things the government will need to think about. So just is it okay if I talk a little bit more about some of the other kinds of challenges that So another kind of challenge, and this I think would be the challenge you're almost certainly to see is, has OSHA issued the rule properly? And you actually probably are following this closer than I am, but when President Biden announced this idea of a OSHA vaccine mandate, a month ago or so, he said, well, OSHA will put in place rules, but OSHA had not yet put in place rules. Last I checked, OSHA still had not yet. I don't know.
No, that they haven't. I'm kind of an OSHA nerd that refreshes the website every morning just to check. And nope, nothing.
I really should be interviewing you rather than vice versa, because you definitely know this OSHA stuff much better than I do. But okay, so OSHA hasn't put in place the rule yet. So whenever they put in place the rule, there will almost certainly be a challenge to whether they put the rule in place properly. And let me just give a little bit of background on this. And this is an area of law called administrative law. So, as you know, in the federal government, there's a vast administrative state with lots of different administrative agencies. Agencies in most cases, have the authority to promulgate rules that have the force of law. But when they do so, they have to adhere to administrative law requirements. Often that means they have to go through what's called notice and comment rulemaking. And courts will sometimes invalidate an agency rule as arbitrary and capricious, and that's a legal term of art, arbitrary and capricious, if the court finds that in the process of the notice and comment rulemaking, the agency failed to consider all the evidence or explain its reasoning thoroughly enough, or if the agency explanation didn't make sense or cut against the evidence. We can't know the procedures OSHA used yet because OSHA hasn't announced the rule, but we can be pretty sure that someone will challenge that rule. One additional point that I think is unique, or at least applies specifically in this OSHA context, is that OSHA is permitted by statute, and you probably know more about this than I do, but OSHA is permitted to bypass notice and comment rulemaking if it finds that employees are exposed to grave danger, and if it needs to put in place an emergency standard to protect employees from that grave danger. So, in other words, Congress has allowed OSHA to skip some of the steps in the administrative process, and OSHA could defend the rules on those grounds. What I've read, and you would probably know this, is that OSHA is planning to go through this route to get it out quickly. But again, you can imagine challenges coming and saying, well, it's not a grave danger, or OSHA, even though Congress has allowed OSHA to skip some of the steps, it still didn't do it right. So that's a long-winded way of saying that there almost certainly will be challenges to how OSHA puts in place the rule. But, and from a legal standpoint, that's really significant. It is worth noting that that's an administrative law question. Did they go through the right processes in putting the rule in place? That's different from a constitutional challenge, which is saying government doesn't have the authority to do this at all.
Yeah. The emergency temporary standard, if it can only be in place for 6 months before they have to kind of go through those processes and put it on the Federal Register. OSHA already promulgated a similar COVID standard, if you will, specifically targeting the healthcare industry. It's kind of flowing under the radar. Not a lot of people know about it, but basically, like at the 6 month period, like it's got to be posted on the Federal Register, and then you're gonna have a bunch of people commenting, about like why this should not become a permanent standard. Because it had to go through the same. Like I live in Virginia, and Virginia had like one of the first emergency temporary standards for COVID, and it just got like ratified, I don't know, like several months ago or something. And now it's so weird. Like it's even though it's a permanent standard now, it's already been revised like 3 or 4 times because it just things have changed so often. And I think the problem with sort of making an OSHA standard permanent is because is going to be the changes in the virus may affect the change in the strategy. So if you sort of codify, what employers are supposed to do or not do, then it's going to be really hard to kind of have like an enforcement mechanism should, we have to zig instead of zag, when we're at like, the epsilon variant or whatever the next variant is.
Right. No, that's a really great point. And, especially nowadays, there's a lot of attack on the administrative state. People say, well, Congress should not delegate all of this lawmaking authority to administrative agencies. But the point you just made is a really good one, that when situations on the ground change so quickly, for instance, you have a global pandemic and there are variants, and the variants are maybe behave differently, that's maybe an instance where you need administrative agencies because they can act a little more nimbly than Congress can in responding to problems. Though, what you said also shows that even administrative agencies, though they can act more nimbly than Congress, they're not terribly nimble either. And by the time that they get a rule out, they can act faster than Congress, but it could be that COVID has changed enough that rule doesn't make a whole lot of sense, 6, 9, 12 months from now. Again, depending on the situation of the ground. So So that's a really good point. And that actually leads to one other point I wanted to make, which is, so I've been talking about, did Congress delegate to OSHA the authority to do this? Another kind of challenge you could imagine is, can Congress constitutionally delegate to OSHA the authority to put in place a vaccine mandate? There's a doctrine in constitutional law called the non delegation doctrine that asserts that Congress cannot delegate its lawmaking authority to administrative agencies. Congress has to pass laws itself. It can't shove that responsibility off on administrative agencies. The Supreme Court has not struck down a congressional statute under this non-delegation doctrine since 1935. As some scholars have put it, the non-delegation doctrine has had one good year and 200 bad ones. So you would think that under current law, the argument that Congress can't tell OSHA you can take care of this problem is a weak one. But as I've said already several times this program, this is a very conservative Supreme Court, and several of the conservative justices on this court have expressed interest in revisiting the non-delegation doctrine and putting more constraints on Congress's authority to delegate its lawmaking power to administrative agencies. My guess, and it's really just a guess, is that if the court does step in and put limits on Congress's delegations to administrative agencies, it would not be in a sort of high-profile political hot-button case like this one, where obviously a lot of people are paying attention to the vaccine mandate. My guess is they would choose some obscure agency that no one's paying attention to and sort of do it more under the radar that way. But I don't know. Again, that is an issue that certainly a legal challenge that could and probably will be brought. And under current doctrine, it would fail. But the Supreme Court has indicated a willingness to depart from current doctrine.
Got it. So, I guess my next question would be, if you had a crystal ball and you could tell the future, what what do you expect to be the first type, broad category of challenge to a vaccine mandate? And if that's too broad of a question, I can narrow it down. So let's just say, with schools, colleges, a lot of colleges are now requiring that, students kind of come in. So how do you think that type of case going in front of the Supreme Court would turn out?
Again, it depends, but I think if a private school a private college put in place a vaccine mandate, say all employees and students at this school need to be vaccinated, I think it would be very, very hard to successfully challenge that. I think a private employer or a private school would have a broad authority to put in place a vaccine mandate. And could there be challenges? Sure, but I think they'd be pretty likely to fail. But imagine a public university putting in place a vaccine mandate for all students and employees. I think there would be challenges to that. And again, you could imagine a few of them. One could be a sort of state constitutional law type challenge saying the university doesn't have the authority to do this. And that would obviously depend on the particulars of that state. My guess is that in a lot of states, public universities do have the authority to put in place health rules that they think are necessary to keep people in their community safe. And in some states, they might even do so with the blessing of the political branches, of the governor and the state legislature, which would insulate it even further. But obviously, that would depend on the particulars of the state laws. Although my guess is that in most instances, Again, the state universities would have the authority to do that. Then you could imagine particular individual objections. In other words, rather than structural objections saying the school or the state doesn't have the authority to put in place a vaccine mandate, the argument would be that that mandate violates my individual rights, my individual liberty. Um, again, it's always dangerous to predict, and the worst, it's especially dangerous to predict because you can easily be proven wrong when things turn out differently. My guess is that a sort of individual rights, bodily integrity, what constitutional lawyers refer to as a substantive due process challenge, that this invades my privacy, my right to make my own bodily decisions. My guess is, like, say, a student at a university brought that kind of challenge, the courts would reject the challenge and say, and cite Jacobson and say, no, this doesn't violate your individual rights. In particular, because if you really don't like it, go to another school that doesn't have this. So I think, I'm not positive that would be the outcome, but the University of Indiana put in place a vaccine mandate a month or so ago. And I think Justice Amy Coney Barrett, who's obviously a conservative, who's the circuit justice for that circuit, I think voted to uphold that mandate. And I would be surprised if that kind of mandate were struck down. Again, if, and this ties back to something we talked about already, if a particular student or employee at that university cited a religious objection, I think a court would be far more likely to step in and say, well, you university have to give a religious exemption. But again, that wouldn't be an across the board, everybody has a liberty interest in not getting a vaccine they don't want. It would be a narrower, you have to come forward and claim that it violates your religion. And my guess is, universities are going to know that the courts nowadays are very protective of religious liberty, and would probably include religious exemptions in the initial policy just to head off that kind of a challenge.
It just dawned on me, like, what would happen if, like, this would never happen, but what would happen if like Liberty University, historically Christian college, had a mandatory vaccine requirement? Could a student apply for a religious exemption at this Christian college?
Well, okay, so one important sort of doctrinal factor here is that the Constitution only applies to state actors. So, in other words, you can't invoke a constitutional claim to religious liberty or to freedom of speech or anything else against against a private actor. Now, it could be that I don't know the terms of Liberty University's contracts, but it could be that a particular employee would be able to point to something in the employment contract and say, like, hey, the contract prevents you from violating my religious liberty, and you're doing that. But that would not be a constitutional challenge. That would be a different kind of challenge. So it's really, the constitutional challenges I'm talking about would really come against only state actors. So either a state university or a state employer or federal government like Osha, things like that.
I got it. So last question, and I should have actually asked this at the very beginning, but we've talked a lot about the constitutionality of vaccine mandates and a lot of different kind of settings, scenarios. Like, as I'm reading about the constitutionality of these things, like the 14th Amendment keeps coming up. So can you briefly, describe what the 14th Amendment is and, how it's sort of being used in a lot of these different cases?
Right. So the 14th Amendment, was one of the three amendments ratified in the wake of the Civil War. And its real purpose was to try to give protections to the newly freed slaves from the oppression that those the freed men and women would almost certainly face throughout the country, but especially in the former Confederacy. Um, um, the 14th Amendment has sort of taken on a whole life of its own and is the basis of a lot of constitutional litigation. The A lot of individual liberty claims that you hear people make are actually rooted in the 14th Amendment. So the argument that the minister made in Jacobson that the vaccine mandate that was, I think in that case, put in place by the city of Cambridge, Massachusetts, was a 14th Amendment argument rooted in the due process clause of the 14th Amendment. Um, and it's a little bit of a misnomer because it talks about the language talks about due process, which sounds like it's about procedures, but the Supreme Court has read into that substantive protections for certain liberties. So within those liberties is right now the right to abortion, although that might be different the next time we talk, depending on what the Supreme Court does in a couple of cases. Um, the right to contraception, and other personal kind of liberty rights. So one of the arguments that somebody can make against a vaccine mandate is that it violates their liberty under the 14th Amendment. Again, for reasons I already explained, I think, under Jacobson, that it's not the strongest argument, but it's also not a crazy argument. In other words, I think it's more likely than not to fail, but it's not certain to fail. Um, the 14th Amendment also does another piece of important work, which is it applies the Bill of Rights, or most of the provisions of the Bill of Rights, against the state governments. So originally, the Bill of Rights, the first 10 amendments, free exercise of religion, freedom of speech, freedom of association, right to keep and bear arms, and so on. Protection against cruel and unusual punishment. Originally, those were protections only against the federal government, not the state government. So, for instance, at least ostensibly, the federal government could not limit your speech because of the First Amendment, but state governments could because the First Amendment did not reach state governments. I mean, in reality, the First Amendment didn't have a whole lot of bite earlier, in the 19th century, but at least in theory, Bill of Rights initially applied against the federal government, not against the state governments. The Supreme Court has interpreted the 14th Amendment as incorporating the Bill of Rights to apply against the states. So for instance, the religious liberty protections of the free exercise clause of the First Amendment not only protects against the federal government invading your religious liberty, but also the state governments. So even though substantively we think of it as a First Amendment claim, if let's say a state put in place a broad vaccine mandate and you had a religious objection to it, that the notion of that free exercise religious objection comes from the free exercise clause of the First Amendment, but that free exercise clause of the First Amendment applies against state governments because of the due process clause of the 14th Amendment. And that was worked out in a series of decisions, mostly in the mid 20th century. And of course, is way more complicated than it needs to be. But that's why people like I have a job.
That's it's true. I mean, like somebody has to read all this stuff, right? It's kind of like all the Osha stuff. Like somebody has to like read, all the CFRs and make it make sense to their employers, So, God bless people like us, right? But well, thank you so much, Eric, for coming on and just helping us wade through some of the constitutionality, legal stuff, whatever, of the vaccine mandates. It's been really, really helpful. I apologize. Josh couldn't be here. I think he'd have a whole lot to offer. But yeah, thanks again for coming on the show.
Okay. Well, it's great as always to see you. Stay healthy. And thank you very much for having me. It was a real pleasure to talk to you.
right, we'll see you soon. Okay, bye bye.